120 words per minute for 9 minutes. 10 seconds more. 5 seconds. Start. The present appeal has been preferred against the impugned order passed by the learned single judge, whereby the learned single judge allowed the writ petition of respondent number 1. The unsuccessful respondent in the writ petition is the appellant before us. It is the case of the appellant that while notification under Section 4 of the Land Acquisition Act 1894 for lands falling in his village were acquired by the government for the public use. On 19/9/1986, compensation was paid to the respondent number 1 on the basis of oral gift given by the recorded owner, which was confirmed by the learned sub-judge. Thereafter, respondent number 1 applied for allotment of an alternative plot. After a period of 1 year from the date of receipt of compensation, and his application was rejected by the appellant's recommendation committee on the ground that he was not the recorded owner of the above mentioned land at the time of issuance of the notification, and also on another ground that the said application was time barred. Adversely affected by the above rejection order, respondent number 1 filed a writ petition before this court seeking a relief of allotment of an alternative plot. The learned single judge in the above writ petition held that the compensation was received after 1 year. Since I have condoned the delay, if any, the respondent numbers 1 and 2 are directed to decide the claim of the petitioner. In view of the above facts and the settled law, the said order is hereby set aside, and the respondent numbers 1 and 2 are directed to reconsider the application of the petitioner and pass a fresh order within 2 months from today. Decision taken by the respondents shall be communicated to the petitioner within 2 weeks thereafter. If the petitioner is still aggrieved with the order passed by the respondent numbers 1 and 2, liberty is granted to the petitioner to approach the court. Feeling aggrieved, the appellants filed the present letter patent appeal. Learned counsel for the appellants contended that the learned single judge has not given any cogent reason whatsoever while arriving at a conclusion to condone the delay in moving the application beyond the period of 1 year. Further, the counsel submitted that the learned single judge failed to appreciate that the respondent was not a recorded owner at the time of the issuance of notification, and therefore the respondent was not entitled to the allotment of alternative plot. Per contra, learned counsel for the respondent number 1 refuted the arguments of the appellants and submitted that, being the only legal heir, the respondent applied for allotment of an alternative plot. It was vehemently urged that a subsequent public notice was also issued extending the time for applying for the alternative plot. Further, it was contended by the counsel that the respondent followed up with the authorities continuously. However, he was always informed that his request was pending, and after a delay of 24 years, the application was rejected, which was communicated to the respondent only in 2012. The learned counsel for the respondent number 2 submitted that no relief has been claimed against the respondent number 2, and thus no order is required to be passed against this respondent. We have heard the learned counsel for the parties, examined the impugned judgment, and perused the material placed before us. At the very outset, it is relevant to reproduce the guidelines for eligibility for allotment of alternate plots. Clause C under the category of eligibility para 1 is stated as under. When the recorded owner of the land acquired dies before notification, allotment is to be made separately to all the legal heirs of the deceased accordingly to their shares recognized by the LAC. But if he dies after the notification, all legal heirs are entitled to one plot of the size to which the deceased would have been entitled. The issue pertaining to whether the respondent number 1 was a legally valid owner of the land in question is concerned. A suit for declaration was filed in the Court of Sub-Judge Delhi. The sole arbitrator, pursuant to the order and in his award, observed that according to Muslim personal law, property can be gifted orally. According to the said law, the donor has to declare the gift, the donee is to accept the gift, and possession of the property is to be delivered by the donor to the donee. It is not denied by the parties that the gift was declared by the donor, the donee accepted it, and that possession of the property was also delivered to the donee. Gift was thus complete and irrevocable. It cannot be impeached on the ground that it was orally made, and hence the oral gift made by the defendant to the plaintiff was legally valid. The plaintiff is owner of the suit property and he is entitled to declaration as prayed for by him. Admittedly, in terms of the award passed by the sub-judge Delhi, respondent number 1 is the valid owner of the land in question, as all formal requirements of making a gift were completed, that is, an offer was made by the donor and simultaneously accepted by the donee. It was made voluntarily without consideration, and thereby the gift was complete and irrevocable, making the respondent a legally valid owner. Simultaneously, it is significant to reiterate and appreciate that the policy framed is a beneficial one to meet the residential requirement of the person whose land is acquired. The liberal construction of the object of the policy, as also the perusal of the guidelines, make it abundantly clear that all legal heirs are entitled to the allotment if the recorded owner dies after the notification. Material on record discloses that the compensation was paid to the respondent number 1 and he applied for allotment of alternative plot beyond a period of 1 year from the date of receipt of compensation. Having already stated the object of the policy, we are of the considered view that this period of approximately 9 months demonstrates that this delay was not a result of any neglect and the same is negligible. Also, it has to be kept in mind that the appellant, who is emphasizing on this delay of approximately 9 months, has failed to act promptly itself by communicating the order to the respondent rejecting the allotment. In this background, we are in consonance with the view taken by the learned single judge. There is no justifiable reason to interfere with the finding of the learned single judge. Resultantly, the appeal, being without any merit, is dismissed.